You may have seen the Karate Kid reboot Cobra Kai. If you're old enough to remember the original movie, you'll remember all the times Johnny Lawrence and his friends bullied Daniel. In the movie, Daniel learned karate, won the All-Valley tournament by crane kicking Johnny in the face, and, as we see in Cobra Kai, went on to be a successful, if somewhat awkward, businessman. But what the Karate Kid and countless other movies don't show is the real harm that can come from bullying, especially bullying that is more subtle than what we typically see on the big screen. Movies also don't usually show the actions school employees should take to prevent bullying and protect themselves and their students from the harmful actions of others. We hope this training will do that. All students and employees deserve to be safe at school and work. This training will give you information about bullying, cyberbullying, hazing and retaliation. We'll also cover discrimination and harassment under certain federal laws and show how bullying, cyberbullying, hazing and retaliation are different from those types of discrimination and may occur separately from each other or in combination. We'll discuss potential student and employee discipline that might be issued to those who engage in this prohibited conduct. And finally, you'll learn about the right of free speech and how it differs for students, employees, and parents. All employees are required by law to complete this training at least once every 3 years. The district may require it more often if needed. This training is based primarily on 4 policies. You should familiarize yourself with them by reading them through at least once, and then referring back to them as needed. They are available on the district website under the Information tab. Policy JDD, also numbered G, B, E, A, Prohibition of Bullying, Hazing, and Retaliation. Policy JDC, Student Discrimination and Harassment. Policy G, B, E, B, Employee Discrimination and Harassment. And Policy JDCB, also numbered G, B, E, B, B, Sexual Harassment.
Let's start with the bullying policy, JDD. This policy prohibits 5 distinct types of conduct: bullying, cyberbullying, hazing, retaliation, and abusive conduct. Each of these terms has a detailed definition in the policy, but we'll just briefly summarize here so you get the idea. Bullying happens when someone intentionally says or does something to another that will cause the other person physical or emotional harm or property damage. The conduct will usually create a hostile or threatening environment due to the pervasiveness or severity of the actions or a power differential between the bully and the target. Cyberbullying is bullying that happens through electronic communication, such as social media or texting. Hazing happens in the context of a team, club, organization, or another program, when, as part of the initiation into the group, or sometimes just due to being a member of the group, a person is subjected to conduct that endangers their mental or physical health or safety. Retaliation under this policy is specific to acts of retribution against someone for reporting bullying, cyberbullying, hazing, or abusive conduct. And finally, the 5th term, abusive conduct. This one is specific to employees. It happens when a parent or student, through repeated conduct, intends to intimidate, humiliate, or cause unwarranted distress to an employee. A few important things to note about these 5 types of behavior. First, with the exception of abusive conduct, they all apply to both students and employees. So not only are students and employees prohibited from engaging in the conduct, but both students and employees are protected from it and can file a complaint if they experience it. Second, the conduct is still prohibited even if the target chooses to participate. When making a report, it's best to do it in writing. The district has created complaint forms to help victims document relevant information such as the name of the respondent, the date and location of the incidents, the names of any witnesses, and a description of what happened. The complaint forms can be found on the district website together with the discrimination and harassment policies. When a complaint is received, the principal or supervisor meets with the applicable district administrators to determine who will conduct the investigation. The investigation is conducted and documented using district forms, and if the outcome is that prohibited conduct occurred, remedies will be provided to the victim, and remedial measures, including disciplinary action, will be taken against the respondent. In student cases, the school administration will notify the parents of the students involved. Now let's talk about discrimination and harassment. State and federal law prohibit discrimination and harassment based on race, color, national origin, sex, sexual orientation, gender identity, age, disability, and veteran status. First, let's quickly review the laws. Title IX is a federal law enacted as part of the Education Amendments of 1972. It prohibits discrimination and harassment based on sex and includes not just equitable opportunities but also prohibits sexual harassment. It protects both students and employees. Section 504 is a federal law enacted as part of the Rehabilitation Act of 1973. Together with the Americans with Disabilities Act of 1990, commonly referred to as the ADA, it prohibits discrimination and harassment based on disability. It protects both students and employees. Students with disabilities may receive a 504 plan or IEP outlining accommodations. Employees needing accommodations must notify their supervisor or the Director of Human Resources and follow the process found in Policy GBEG, Workplace Accommodations for Employees with Disabilities. The Civil Rights Act of 1964 prohibits discrimination and harassment based on race, color, religion, sex, or national origin. It protects both students and employees. Finally, a number of other laws provide protections to employees, such as the Age Discrimination in Employment Act, the Older Workers Benefit Protection Act, the Equal Pay Act, the Pregnancy Discrimination Act, the Uniformed Services Employment and Reemployment Rights Act, and the Utah Anti-Discrimination Act.
Sometimes discrimination and harassment based on these protected classifications happen as part of conduct that is also bullying or hazing. When this is the case, the conduct will be investigated as a potential civil rights violation and may carry more significant remedies for victims and more severe discipline for respondents. Other conduct may constitute discrimination or harassment but not rise to the level of bullying or hazing. NEBO's discrimination and harassment policies, JDC and GBEB, list examples of the types of conduct that are prohibited. You should review those lists and examine whether you find yourself engaging in any of the prohibited conduct. Some people have referred to things like epithets, slurs, stereotypes, name-calling, jokes, notes, and drawings as locker room talk, or excuse it by saying that's just him, but he's really a good person. In reality, the conduct is harmful and will not be tolerated. As an employee, if you become aware of students engaging in prohibited discrimination or harassment, you have a duty to notify the school administration. If you believe you have been subjected to discrimination or harassment, you must immediately file a complaint with your immediate supervisor. You can use the complaint form found here on the district website, but you can also make a verbal complaint. If you are not comfortable reporting to your supervisor, you should report to the district civil rights coordinator shown on screen. Supervisors, administrators, and district officials will ensure that an investigation is conducted. The investigation procedures laid out in policies JDC and GBEB are followed for complaints of discrimination and harassment but also for complaints of bullying and hazing. They will typically involve interviews of the complainant, the respondent, and any witnesses. Other evidence, such as surveillance video and electronic communications, will also be gathered. In the end, the investigator will prepare a written report, and if remedial or disciplinary action is needed, it will be taken. As in the case of bullying or hazing, retaliation is prohibited in cases of discrimination or harassment. That means acting out against another person for their involvement in an investigation is a separate violation that will result in its own disciplinary action in addition to any that might be imposed as a result of the initial investigation. On the other hand, anyone found to have filed a false, malicious, or frivolous complaint will also receive disciplinary action.
Now, sexual harassment deserves its own comment here. As we've said, it is prohibited by Title IX. New federal regulations in 2020 describe a much more complex investigation procedure for allegations of sexual harassment, as well as a more detailed explanation of what sexual harassment is under Title IX. These details are spelled out in Policy JDCB, also GBEBB. Students and employees found to have engaged in prohibited conduct will be subjected to discipline. Student discipline is administered according to Policy JD, Student Conduct and Discipline, and may include detention, in-school suspension, short-term suspension, long-term suspension, administrative transfer, expulsion, exclusion from or loss of extracurricular activities, probation, or alternative educational placement. Employee discipline is administered according to Policy GCPD, employee discipline, administrative leave, and orderly termination. It may include directives, warnings, reprimands, probation, disciplinary transfer, suspension, reduction in pay or hours, or termination.
Finally, a word on free speech. The First Amendment to the United States Constitution prohibits the government from abridging the freedom of speech. As a public school, Nebo School District is bound by this. However, the First Amendment doesn't mean anyone can say anything they want whenever they want. Here are some basic rules for how it applies to students, employees, and parents. As the U.S. Supreme Court has said, students do not shed their constitutional rights at the schoolhouse gate. But while the First Amendment protects their speech in general, the Supreme Court has identified some areas where school districts can limit student speech. For example, students may be disciplined for speech that causes a substantial disruption to school operations. They may also be disciplined for speech that is lewd, vulgar, indecent, or that promotes illegal activities such as drug use. Thus, student speech that constitutes bullying, cyberbullying, hazing, abusive conduct, discrimination, harassment, or retaliation is not protected by the First Amendment. Likewise, while employees enjoy the protections of the First Amendment as private citizens, those protections don't allow an employee to engage in speech that violates district policies. In fact, what an employee says while acting in their capacity as an employee is not covered by the First Amendment.
And finally, parents also enjoy the free speech protections of the First Amendment. But like students and employees, they are not allowed to disrupt the operations of the school. The district may take action to protect its students and employees against speech by parents and others that violate its bullying, discrimination, or harassment policies. We hope this training has been helpful. If you see or experience any of the conduct discussed here, please report it to your supervisor, the director, human resources, or the civil rights coordinator. Here's wishing you a safe and healthy year.